You know, the Constitution has been debated since before the ink was dry. Okay, so this is actually one of those old debates that is still out there, all right? And I think all of us in here, regardless of where we stand on either side of this debate, agree that our country's in trouble. I personally think that has a lot to do with federal overreach and too much state giving in. That's my personal opinion there. So anyway, Michael Patrick Leahy has agreed to be the moderator. And of course we have Mark Pulliam, who is in opposition to nullification, and we have Jeff Cobble, who wrote the nullification legislation. You know, Michael Patrick Leahy is the founder of the Tennessee Star, and how many stars are we up to now?
13.
13 stars. Whoa, 13 stars. That's interesting.
I know.
Okay. And you're also the founder of the Constitution Bee, which is
For high
something you
school
do with all
students,
this.
right.
That's what, junior high?
High school students.
High school
yeah.
students? Okay, great. And author of several books on the Constitution. So, but we appreciate him coming out here to moderate. Both speakers will get equal time to do their opening statements. We have a few questions for them. After the first hour, we'll take a break and come back and finish up the questions and then do the closing. So just to keep this thing flowing, let's hold all applause to the end, okay? No boos, but all applause to the end, okay? Okay, yeah, absolutely. So without dragging this out anymore, and I'll be the timekeeper, I'll be up here, and they'll get a warning when they get to the 5-minute mark where it's applicable, the 1-minute mark, and then I have a little timer to let them know they're 10 seconds out. So I'm going to turn it over to Michael now, and thanks again.
All right, welcome everybody. Thanks for coming today. I think, Ray, how long have you been doing this? 15 years? I think a long time. I think I've been to a number of these, and those of you who haven't met me, I am the founder of the Tennessee Star, the only really conservative news outlet in the state of Tennessee as a news outlet. Also, I'm the host of a radio program. I've been a host here in Nashville weekdays for about 6 years. For about 5.5 years, I was the morning host from 5 a.m. to 8 a.m. I got up at 3:30 every day on the iHeart station. And then in December, I moved over to 760 a.m. WENO here in Nashville. It's part of the John Fredericks radio network, on from 9 a.m. to noon. We're now in 20 markets, so we are growing. So that's a little bit of my background. You may have seen me of late on the television news, yes. Because I am a plaintiff in the case to obtain the Covenant Killer writings, or the manifesto. I'm a plaintiff in the case in the state chancery court as well as in federal court, and of course that happened in March of 2023. We filed a lawsuit to get all those writings in accordance with the Tennessee Public Records Act. A chancery court judge here in Tennessee, Aisha Miles, reviewed that for some time. We, last month, legally obtained about 80 pages of the killer's writings and some other documents. We started writing stories based on that, although we didn't publish the documents, even though we have the right to do that. The judge, after getting a complaint from a local reporter at WSMV television, asking her to file a contempt of court charges against me, the judge sent a show cause order for me to show up and explain why she shouldn't put me in jail for exercising my First Amendment rights. And so that big hearing was on June 17th. The judge, instead of asking about why she shouldn't put me in jail for contempt of court causes, talked about something else entirely. And subsequently, she ruled in a very bizarre way on July 4th that the writings would not be released on the grounds that they were copyrighted. It's a terrible decision. We're appealing it, by the way. And she's still trying to hold the sword of Damocles over my head to put me in contempt of court in jail for 10 days. She won't be able to do that. But I had to hire a First Amendment attorney, so I'm very familiar with the First Amendment, guys. And he did. His name is Dan Horowitz. Horwitz. He is left-wing, but also a spectacular First Amendment attorney. He kept me out of jail. We are likely not only to appeal and win on appeal in that case, but we're also likely to succeed in filing a claim of judicial misconduct against the judge, because it is not illegal in America to exercise your First Amendment rights. That said, let me introduce our two speakers today. Speaking in the affirmative is an attorney from Greenville, Mr. Jeff Cobble. Say hello to Jeff. And speaking on the negative, on the nullification issue, is now a resident of East Tennessee, Mark Pulliam.
Yep, thank you.
Now let me say a word about our two gentlemen here who are speaking. Jeff Cobble is an attorney and counselor at law, owner of the Cobble Law Firm, which has offices in Tennessee and Pennsylvania. He's been admitted to the practice of law in the state of Tennessee and Pennsylvania and in federal courts in those states. He has a Bachelor's of Science degree from Pensacola Christian College and a JD from Regent University. He served as an affiliate attorney with a number of First Amendment organizations, such as the Rutherford Institute, the National Legal Foundation, the Christian Law Association, and the American Center for Law and Justice. Welcome, Jeffrey.
Thank you.
And arguing on the negative side, Mark Pulliam. He is a lawyer and writer, now living in East Tennessee. He's a graduate of the University of Tennessee School of Law. He practiced law in California, and my goodness, and survived for 30 years. He was recognized as one of the best lawyers in America. He now writes mainly on legal topics for a number of publications: the Los Angeles Times, the National Review, the City Journal, American Greatness, American Spectator, the Federalist, the American Thinker. These are all great publications. He writes at his law commentary site, and I love the title of this: Misrule of Law, a Chronicle of Legal and Judicial Mischief. And boy, do we have a lot of that right now. Now let's talk about the format for the event here today. Each side will have 15 minutes for an opening statement. Then we will have a series of about 5 specific questions. We're going to take a break after the second question. In most questions, each side will have 5 minutes to respond. There's one particularly lengthy question, which each side will have 10 minutes. After we'll take a break at about the 1 hour mark. And then each side will have about 10 minutes for their closing comment. So, and there are no rebuttals, so this is just going to be a pure discussion. And I think we're ready to go with that. Mark Pulliam won the opening toss, and so he will begin his 15-minute opening statement now. Mark Pulliam.
All right, thank you. Well, good afternoon. As Michael just said, my name is Mark Pulliam, and it is good to see so many concerned citizens engaged in the political process. We need more patriots who are engaged in the fight. I want to thank the organizers for inviting me this afternoon, and to all of you for attending. I see some friends in the audience. I hope we remain so. This event is styled as a debate, but I regard it as more like a conversation. In truth, all of us here are patriots and constitutional conservatives, and therefore allies. I disagree with Mr. Cobble in some respects, but agree that our nation is headed in the wrong direction. The topic of nullification is complicated, and we are going to be covering a lot of ground this afternoon, some of it quite technical. For those who would like to read a more detailed presentation with references, I have written an article on my blog, Misrule of Law, entitled Constitutional Conservatives Should Recognize that Nullification is a Chimera, Not a Panacea. And my blog is www.misruleoflaw.com. So, in terms of areas of agreement, I agree with probably everybody in this room that the country is in serious trouble. We need to fix it. The question is how. This is a question all conservatives must be thinking about. Nullification is appealing because it seems to be a quick fix. Pass a law, and the federal Leviathan will be instantly tamed. Not all problems are easily fixed, however. Embracing nullification is like buying a lottery ticket and hoping to get rich. The more realistic solution to building wealth is to work hard, save more, and spend less. So it is with preserving the republic. There are no silver bullet magic solutions to the challenges we face. Wishful thinking and good intentions are not a substitute for viable strategies and hard work. There is a right way and a wrong way to challenge objectionable federal laws. The right way is through elections, litigation, constitutional amendments, political protests, and influencing the appointment process for Supreme Court justices. The wrong way is outright defiance. I am in the unenviable position of telling you an unpleasant truth. Nullification has been tried or at least asserted at various times in our history, and it has never been successful. It will not be successful now. Conservatives should find a more constructive strategy to support. Nullification is ultimately a legal issue. I approach the topic as a lawyer, just a lawyer. I am not a historian, philosopher, or revolutionary theorist. I have been accused of worshiping at the altar of judicial supremacy, but I merely follow the law. After all, conservatives are supposed to support the rule of law. Nothing I say today is particularly original. Few legal issues are as well settled as this one. As a legal matter, the notion that states can unilaterally nullify federal laws with which they disagree is unsupported by the text of the Constitution, contrary to 200 years of Supreme Court decisions, and without precedent in our nation's history. If Tennessee were to adopt SB 2775, the law would be quickly declared unconstitutional and achieve nothing. Attorney General Scarmetti's opinion, in my view, correctly summarizes the applicable law. Now, it's important to understand that there are different flavors of nullification, not all of which are objectionable. Protesting objectionable federal is perfectly legitimate. Ditto public criticism and even organized opposition, which James Madison referred to as interposition. Ditto refusing to cooperate with the federal government regarding enforcement of objectionable laws. Ditto refusing to provide funds or other resources, including manpower, to enforce objectionable laws. Many conservatives objected to Obamacare and for decades protested against Roe versus Wade, and that is perfectly legitimate in our system. What you cannot do, and this is the only true form of nullification, is to unilaterally declare federal laws to be unconstitutional and then to refuse to comply with them or to interfere with the federal government's enforcement of them. This is because of the supremacy clause of our Constitution. In order to understand the importance of the Union and the importance of the Constitution, one must recall the early history of our nation. And I, again, am not an historian. Although we have a historian here, I want to recognize Amanda Klug, who is a graduate of Hillsdale College and a PhD student at the University of Tennessee working on her doctorate. And she lives in East Tennessee and is willing to speak to groups on this subject. And I'm sure she'd be happy to chat with you during the break. And she is the expert. Now, for about a decade, between the Declaration of Independence and adoption of the Constitution, the United States was loosely governed by something called the Articles of Confederation. And for whatever reason, the Articles of Federation have just been lost in time, that people don't talk about them, don't refer to them, but they're very important. The original 13 states organized themselves into a loose confederation that lacked a judiciary or a meaningful federal government. It was a failure, nearly preventing George Washington from having the resources necessary to fight the British and to manage civil unrest, such as Shays' Rebellion. The Constitution is what made us a union, binding us together as a nation. Under the Articles, we were not yet a nation. We were the United States in lowercase. The Constitution formed what we now enjoy as the capital letters, United States. The Constitution is regarded as the law of the land. And I believe today's program began with the Pledge of Allegiance, which refers to us as one nation under God, indivisible. So, nullification would take us back to where we were before the Constitution, under the Articles of Confederation. The defects of the Articles were a major theme in the Federalist essays. Here's a brief history of the nullification doctrine. In 1798, John Adams was president. He was a Federalist. Congress was in the hands of the Federalist Party, and it had enacted a very unpopular law called the Alien and Sedition Acts. And the most unpopular part of it was the Sedition Acts, which literally made it a crime to criticize the federal government. And this was directed at the Republicans, who were the political opponents of the Federalists. And so in 1798, we had 16 colonies, 16 states at the time. Two of them, Virginia and Kentucky, passed resolutions condemning the Alien and Sedition Acts, saying that we believe it's unconstitutional and we're opposed to it, and they expressed some very strong rhetoric. And as it turns out, Thomas Jefferson ghost wrote the Kentucky Resolution, and James Madison ghost wrote Virginia's. These resolutions, which for whatever reason have spawned a lot of the current nullification talk, achieved nothing. They had no legal significance. No other state joined with them. And in fact, many of the states issued resolutions criticizing and condemning Virginia and Kentucky for questioning the unity and of the Union and so forth. Now, Madison's resolution for Virginia did not use the word nullification. He talked about interposition. Jefferson's for Kentucky did, and as we will talk about later in our dialogue here, Madison spent a good part of the rest of his career distancing himself from the Virginia Resolution and from Jefferson's contribution to the Kentucky Resolution. But they did not, it had no legal effect. The second time nullification became a topic of discussion in the United States was in 1832, when there was a dispute over a tariff law. And at the time, tariffs were the primary measure of raising revenue. We didn't have an income tax at the time. And states that exported goods, which were largely the agrarian states in the South, selling cotton to England, opposed the tariffs because it invited reciprocal barriers to trade. And so John Calhoun, who was from South Carolina, took a very bellicose attitude towards this particular tariff law and got the state of South Carolina to oppose it and say that we were going to interfere with the federal government's right to collect tariffs in South Carolina, which led to a showdown with the president at the time, our own Andrew Jackson. The next go-around, and needless to say, John Calhoun lost that debate, and there was no interference with the federal collection of tariffs in South Carolina. The next time this came around was in the 1850s, where the nation was divided between slave states and non-slave states, and some of the northern states that were opposed to slavery were interfering with the fugitive slave laws, which required states to surrender fugitive slaves if they were apprehended, if they ran away and were apprehended. And in two Supreme Court cases, the Prigg case and Abelman case involving Pennsylvania and Wisconsin, respectively, the Supreme Court said states cannot interfere with federal law. They cannot overrule federal law. Federal law is supreme. But the biggest, and for present purposes, most compelling denunciation of nullification came in the wake of Brown versus Board of Education in the 1950s. Brown versus Board of Education, as you know, said that segregation in the nation's public schools was unconstitutional. It was a very unpopular decision. Many southern states were bitterly opposed to it. And in Arkansas, the governor said, we're not going to integrate our schools, and called out the National Guard to prevent the integration, even though federal courts had ordered it. Well, Eisenhower sent in the 101st Airborne, and the schools in Little Rock were integrated. And then when other states tried to resist, Alabama and Mississippi at their state universities, you may remember George Wallace standing in the doorway, and federal troops were brought in to enforce these federal court orders. Now, the defiance of these states prompted the Supreme Court to issue a decision, Cooper v. Aaron, in 1958, that was not just a unanimous decision, it was a decision that all 9 of the justices signed. No other decision in Supreme Court history has been signed by all 9 justices. And we will be reading from this later in the discussion, but it emphatically and clearly denounces and says states cannot decide willy-nilly what laws are going to follow, and when the Supreme Court has spoken, or the federal courts for that matter, states must comply. So disputes between states and the federal government invariably end up in court. This is how disputes are resolved pursuant to our Constitution. Nullification, at least in its more extreme forms, is a form of civil disobedience or even rebellion. Some call it secession light. This is not a viable strategy. Now, nullification has spawned a large body of commentary, most of it unfavorable. Many scholars on the right have weighed in against nullification. David Barton, Mark Levin, Randy Barnett, most conservative think tanks. Even the New American, published by the John Birch Society, has conceded that, quote, in today's American history books, nullification is treated as a fringe idea at best and treasonous at worst, close quote. But the only authority that matters is the Supreme Court, which has spoken emphatically, not just against this. And this is some language from Cooper v. Aaron. Quote, Article 6 of the Constitution makes the Constitution the supreme law of the land. In 1803, Chief Justice Marshall, speaking for a unanimous court, referring to the Constitution as the fundamental and paramount law of the nation, declared in the notable case Marbury v. Madison that, quote, it is emphatically the province and duty of the judicial department to say what the law is. This decision declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, and that principle has ever since been respected by this court and the country as a permanent and indispensable feature of our constitutional system. And so I will leave it there. The one other thing they said in Cooper v. Aaron is if the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery.
Thank you, Mark, for that opening statement. Now, Jeff Cobble, arguing in the affirmative for nullification. 15 minutes for your opening statement.
Thank you very much. I've kind of had it a little bit easy. I do presentations on nullification. I've done them for several years. And so I've altered my presentation a little bit for this purpose. First of all, let me say I agree with Mark that we have a complicated issue. I agree that we should not be enemies on this issue. We're having an intellectual discussion. We all recognize there's a problem. The issue is how do we solve it? And so we need to be thinking about the best way to try to solve the issues. And I believe that nullification is viable. It is not a panacea. No legislation passed by Tennessee, any other state, or even the United States Congress is going to fix the swamp that we're in. It's going to take a return to God, a return to values. One nation under God, indivisible. If we're not under God, we're divisible. I'm going to tell you. When we move away from God, we're going to be divisible, and that's where we find ourselves. So I'm searching for solutions short of a bloodbath, short of secession. And I'm suggesting to you that nullification is a viable strategy by which we can solve some problems. And if enough people understand the concept, if enough states will stand on the concept of nullification, which is simply a code word for states' rights. states' rights. And so I want you to think as we talk about the topic today, is there such a thing as states' rights? If there is, what are they? How do we know? And how are they enforced? My solution is that states can enforce their own states' rights. I want to be fair to Mark, I believe Mark says we can't enforce states' rights. The federal government has to tell us if we have these rights or not, whether by Congress or by the executive or by the Supreme Court. And I completely disavow that concept. And so today, I want to take us back to elementary school on the topic of what are rights, how do we know, how is our government formed, and I want to move through these slide presentations pretty quickly because there's a lot more than I've got to cover. But let me try to get this started here. Make it larger, and let's go from the beginning here. All right, so let's move kind of quickly. So first of all, we've talked about the Constitution. What does the Constitution say about the concept of states' rights? Does the Constitution authorize states to assert their rights? If so, then how does a state go about asserting its rights? These are all fair questions. Would you agree? There are at least 8 provisions of the United States Constitution which extend to the concept or the topic of states' rights. I don't have time to cover all 8. I've only got 11 minutes and 50 seconds left before I have to sit down. Before we look at the U.S. Constitution, we must understand that document in its place in time. It's a historical document. There's a historical record. We must understand it in its place in time. First, before the Constitution, we were under England. Before the Declaration of Independence, England made the laws. The king appointed the judges. The king appointed the sheriffs. The king appointed the mayors, the governors. We were basically British citizens. Then in 1776, the Declaration of Independence says that we become, note the language, we become free and independent states. Now, I teach a course on the U.S. Constitution, 40 hours. And one of the trick questions, it's not a trick question, but it winds up being a trick question, is true or false? The Declaration of Independence made us a free and independent nation. False. It made us free and independent states. And that's an important concept. Free and independent states. So here we go. We, therefore, the representatives of the United States, I'm skipping some parts here, solemnly publish and declare that these colonies are and of right ought to be, here's their language, free and independent states. And that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other things, acts and things which independent states may of right do. They make they tie this into natural law. Independent states don't need permission to do anything. Independent states are independent and they are under God, and they may act under God according to their own decisions. They don't need permission. That's how we started after the Declaration of Independence. Then, as Mark has referenced, a part of history we don't really look at much is that we did form a loose confederation. Curiously, in that confederation, called the Articles of Confederation in 1781, the states that joined all said no changes could be made to the Articles without unanimous consent. What do you think of that? What if we had unanimous consent to change anything today in America? Nothing would ever get changed. But they said the power of the Confederation is limited, and no one may expand the powers of that Confederation unless every state agrees. Now, we abandoned that concept by going to, in 1787, to the United States Constitution being proposed, and then 1 year later being ratified. Now, these are things I believe, facts that Mark and I will agree on. This is the historical record. What the question is, what now then is the effect of this United States Constitution being ratified? And so that's what we want to talk about. I want to remind you of this, a very important point. It says, when reflecting upon the ratification of the United States, it should be noted that no one signed it on behalf of the federal government, because no federal government existed. The U.S. Constitution created a federal government. There was no president, there was no courts. So, it is thus historically and logically sound to call the United States Constitution a compact between the states. Now, there are going to be thousands multiple thousands of legal scholars who are going to tell me I'm wrong about that. And they can talk all they want to. Saying it loudly, saying it longly, saying it for 200 years doesn't make it so. It is a compact between the states. And there's no other way to view it. So, keep in mind that the people, we the people of the United States in the preamble, and then the states, they each had a house, right? The House of Representatives was the people's house. The Senate was the state's house, at least before the 17th Amendment. The people and the states are the creator of the federal government. And as we all know, the creator is always greater than the created. This is logic. This is historically sound. It's legally sound. Now, what about Tennessee? Tennessee comes along in 1796 as the 16th state. It says, here in our Constitution, what about, it says, whereas the people of the territory of the United States south of the river Ohio, having the right of admission into the general government as a member state thereof, notice the language, consistent with the Constitution of the United States. Our own Constitution says we are consistent with the Constitution of the United States. I'm skipping some parts for time. By their delegates and representatives in convention assembled then on the 6th day of February in the year of our Lord 1796, ordain and establish a constitution or form of government, and mutually agreed with each other to form themselves into a free and independent state, by the name of the state of Tennessee. Now, that's historically proven. It's in the historical record. We are, as the 13 original colonies, now free and independent states if admitted to the Union. And we were admitted to the Union. One of the things you may not know about, this comes from, going off the top there. This is from the Tennessee Secretary of State's records. Anybody know what a blue book is? Go to your blue book, read the portion about the Tennessee Constitution. Here's what it's going to tell you. The first Constitution of the state of Tennessee was written in Knoxville during the winter of 1796, the year the state was created from the geographic area known as the Southwest Territory. The first Constitution was not put to a vote of the citizens of the new state for ratification, but was approved by Congress. Tennessee joined the Union with the approval of the United States government, not the approval of the people. And they read that very statement in there that said Tennessee is a free and independent state. And they voted to let them in on the basis of that statement that we are forming a new state and we are a free and independent state. Now, what does the U.S. Constitution say about powers and rights transferred to the newly created government? The idea is we are a free and independent state. In our compact with other states, we gave certain powers and certain rights to the newly created government. And I acknowledge that we did. I am not saying the states are supreme in everything. The states are supreme in areas reserved to the states. The federal government is supreme in areas given to the federal government. And the question is, what was given? And here's how we know. So I've got to move quickly. The U.S. Constitution, we're looking at Article 1, Section 1. It says, all legislative powers herein granted, in this Constitution, herein granted shall be vested in a Congress of the United States, which shall consist of a Senate, House of Representatives. Now, okay, maybe you can read it. So listen, prior to the ratification of the U.S. Constitution, the federal government had no power because no federal government existed. Prior to the ratification of the United States Constitution, all power was vested in the people and the states. After ratification of the United States Constitution, a federal government was created. After the ratification of the U.S. Constitution, the people and the states granted legislative, which is lawmaking, power to the federal Congress, which was the House and the Senate. And then number 5, since all legislative power was given to Congress, then the president cannot make a law. Here's the question. If the president does something and he says it's a law and the federal government won't stop him, do the states have a right to stop him? I say yes, and that's nullification. You don't have the authority, President, to do that, nor do any of your administrative agencies have the authority to do that. Okay? And the courts cannot make a law. If all legislative power, all lawmaking power is given to the Congress, then they can't make a law either. And so what do we do when the U.S. Supreme Court says we're making a law about this? Or they wouldn't call it that, would they? We're issuing our decision which has precedent. And we can do nothing about it? I'm sorry. We are the superior. We're the creator. We created you. So, was this grant of legislative power to Congress in Article 1, Section 8? in Article 1, Section 1, was it unlimited? If so, if we gave unlimited lawmaking power to the federal government, then the states have no legislative powers left, or at best, only with permission. All legislative rights would have been given to the federal Congress. If it's not unlimited power, then what were the legislative limitations and how do we know? And so, not surprisingly, the answer is in the U.S. Constitution. So let's look at Article 1, Section 8 of the Constitution. The Congress shall have power to, notice a similar language, Congress shall have power to, this is what they can make laws about, and here's our list. The first one's off the top, sorry, but it's tax, spend, and borrow. No one needs to call their representative and say, please do this. They figured that part out. They know they can tax, spend, and borrow, but it's legitimate if it's for the general welfare. It's permissible. They can, and I'm shortening the list. It's not numbered in the Constitution, but they can regulate interstate and international sales. They can make rules for citizenship and bankruptcy, naturalization. We've got a big issue between Texas and the federal government now, and who has the authority to protect the border? And Texas does. I don't care what the Supreme Court says. They were not given authority to do that. Okay? So Texas has that authority. They only make rules for naturalization, not defending borders. Number 4, they can coin money, punish counterfeiters, establish post offices, patents, copyrights, trademarks, weights and measures, create courts below the Supreme Court. You know, the U.S. Constitution only created one federal court, the Supreme Court. Congress created the rest of them. They could abolish them all and just have one Supreme Court. And then 8, rules of war and the U.S. military. And here's the most important one to get. Making laws governing U.S. land and property. Okay? They can control the areas that they own. And one of the big problems we have in this country is that the federal government's collecting more and more land. That gives them more and more control. But where they're doing these things, they are supreme. The states ceded that power to the federal government when we signed the Constitution. But here's what you need to know. That's the end of the list. We gave them no other powers than that. So, conclusions. The legislative power of Congress is limited. Congress has no power to make rules, laws, or regulations in any area outside the bounds of Article 1, Section 8 powers, and arguably a few things under some amendments. Arguably under the 14th Amendment, which my answer to you on Cooper versus Aaron is that 14th Amendment gave them the power to do that, so it was legitimately federal. But the question is, other things would not be federal. Then the people in the states retain the power to make all other rules, laws, and so forth. So,
we thank you, Jeff.
Thank you.
All right. Now we move on to, thank you, Jeff Cobble. Now we move on to the question portion of this. And in this, we'll have 5 questions. In the 4 of them, each person will have 5 minutes to respond. I want to set up the first question, though. And that is just some information for you. On March 6, Attorney General Jonathan Skrmetti issued a ruling on the constitutionality of Tennessee legislation providing for the nullification of, quote, unconstitutional federal action. This was actually Senate Bill 1092, which I believe Mr. Cobble drafted and was introduced by State Senator Janice Bowling in the State Senate and Bud Hulsey in the House of Representatives. So the question to the Attorney General, which the Attorney General in this state is empowered by the state constitution to provide opinions to questions posed to him by members of the Tennessee General Assembly. The question was, is Senate Bill 1092 of the 113th Tennessee General Assembly first session of 2023 constitutional? And the opinion rendered in March of 2024, Senate Bill 1092 is constitutionally infirm. There's more on that, and I'll let Mr. Cobble and Mr. Pulliam respond to that. Here's a question for you, Mr. Pulliam. You have 5 minutes. Can you please define nullification, and was the concept of nullification supported by our founders?
Yeah, thank you. So nobody disputes that states have rights, that Article 10 amendment, the 10th Amendment says, all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. But at the same time, we have a constitution that created a national government, unlike the Articles of Confederation. So the national government has powers. We have something called dual sovereignty, which was unprecedented in human history, where a country had a form of government where states were sovereign, but the national government of which they were part was sovereign also. And this is the riddle that we've been struggling with since the Federalist Papers, when we were deciding whether or not to ratify this new Constitution that was written in the summer of 1787. And the answer to a lot of these questions about what happens if states or the national government are in conflict is that the national government is supreme. That's what the Supremacy Clause means. On matters involving federal law, there must be an ultimate authority, one voice, because we are one nation. Under our system of government, when the question becomes a matter of constitutional law, that voice is ultimately the U.S. Supreme Court. Now, nullification, in its most extreme form, means that states can decide on a carte blanche basis which federal laws they wish to follow. That because they may have different opinions about whether this law exceeds the scope of whatever provision of the Constitution is cited. And nullification is a broad topic, and it's used imprecisely to refer to many things, many different things, not all of which are controversial. Resolutions by state officials expressing opposition to federal law is okay. Declarations of non-cooperation, such as cities proclaiming themselves sanctuaries for illegal aliens, is okay. Even enacting state laws permitting the sale and use of controlled substances banned by federal law are permissible because states cannot be compelled to enforce federal law because states have rights. Federalism forbids the national government to commandeer state resources to enforce federal law, and that dates back to the fugitive slave cases in the 1850s. Neither, however, can states interfere with the enforcement of federal law or unilaterally override the federal court's interpretation of the Constitution and federal statutes contrary to the Supremacy Clause. Now, proponents of nullification sometimes wrap all those things together in the same package. And I don't have a problem with many things that fall under the umbrella of nullification. But what you cannot do, what states cannot do under existing constitutional law is second guess the decisions of the federal courts about what is constitutional and what isn't. And the statute, SB 2775, is broad enough to cover all forms of nullification. And but my core objection is to the ability of states to unilaterally decide we don't agree with this federal law or that federal law on the grounds that it's unconstitutional. Now, this Justice Joseph Story, who was a noted constitutional scholar, wrote in 1840, and he said, without the judicial power created in Article 3, which is the article of the Constitution that creates the federal courts, quote, the laws of the Union would be perpetually in danger of being contravened by the laws of the states. The national government would be reduced to a servile dependency upon the latter for the due execution of its powers. Regarding the Supremacy Clause, Story had this to say, quote, allowing states to second-guess the validity of federal laws would be a solecism so mischievous and so indefensible that the scheme could never be attributed to the framers of the Constitution without manifestly impeaching their wisdom as well as their good faith. Indeed, he went on to say it would reduce the national government to an idle mockery. And we will, in answer to some of the subsequent questions, examine what if, nullification goes both ways and it wouldn't be limited to Tennessee. What happened if all 50 states got into the picture and started second-guessing federal law? Where would we be? We would be in a Tower of Babel. We would have chaos, and that's not what the framers of the Constitution intended.
Thank you, Mr. Pulliam. The same question for you, Mr. Cobble. Can you please define nullification And was the concept of nullification supported by our founders? You have 5 minutes.
Thank you. I think Mark's done a good job of describing what nullification is. He's correct that there's a lot of different flavors on exactly what nullification is, but the proper understanding of nullification is a state asserting that the federal government has gone beyond its appropriate powers. And that can be a circular reasoning question. I mean, so the question is, who decides if they've gone beyond their powers? And I just take the position the states are the ones who have a right to decide whether the federal government's gone beyond its powers. So my understanding of nullification is that our state officials, for example, all members of the General Assembly, take an oath to uphold the United States Constitution and the state constitution. Now listen to me carefully. The United States Constitution says limited power. So I've violated my oath if I'm a member of the General Assembly and I let the federal government do things it's not supposed to do. I'm not attacking the Constitution. I'm supporting the Constitution. The question is, do they have to agree with me on that? And my answer is no. I have a different view of what the country would look like. I think it'd be a beautiful thing if all the states did exactly what Mark said. Because I don't want a homogenous country. Listen, there are people in this country I'm not going to get along with. That's just a fact. And some of them are moving here from some of those places, right? And we have to be careful. And I believe that competition's a wonderful thing. Let competition work. Find out what, I mean, if you want to have prostitution, Nevada's got prostitution legalized, I say let Nevada have it. Why do I care? I don't want it here. But that's not something given to the federal government. We don't need to be all one people in that sense. The federal government needs to go back inside its small little box. Let me just tell you, there would not be fights over the president and the Supreme Court. Think about this. If we took all the things off the table, go back to that list of 9 things, post offices, national parks, so forth, federal let the federal government do those things and let the states take care of employment, education, energy, commerce of stuff within the states, and let each state compete. Let Tennessee compete with Georgia and Kentucky and North Carolina. It'd be a wonderful thing. Competition works. Competition under God's law. Competition with morality works. I think that's a fantastic thing. And so what I see nullification as being is the states telling the federal government, no you don't. You can't go there. You don't have the authority. Now, nullification is not the states repealing a federal law. States don't have authority to repeal an act of Congress. It's not the states, reversing a Supreme Court decision. We don't have the authority to do that. It is a state saying, much like Mark said, anti-commandeering, we will not support that. You can't do that in Tennessee. We say you're out of line. We say, no. Can't do that. Not what we want. Now, one of the things that sometimes nullification is mischaracterized as states not following any law they don't like. That's not what nullification is in my book. There's lots of things the federal government does that's within their powers that I don't like. States have no right to nullify things that are legitimately given to the federal government until we amend the Constitution. But when they stick their toe over the line, or sometimes they're just walking completely over the line, states have a right to say, no, you don't. Number one, we will not recognize that as valid law in Tennessee. Number two, we will not support it. We will not allow it to be enforced within our territories. And in fact, one of the things our bill does says that depending on who's controlling the purse and things along that line, we won't even spend any money to help you do it. We might even spend money to oppose you to do that. So I believe, in the first place, that Attorney General Scometti, and he's, by the way, I don't know him personally, but I believe he's one of the better attorney generals we've had in a while. And it's not a personal attack upon him. But attorneys, people trained in law school, bow to the idea of judicial review. And let me just tell you right now, I completely disavow judicial review. I don't care if it's been 200 years. I don't care if it's been 2 million years. If it was wrong from the beginning, it's still wrong now. And the concept that the courts, the Supreme Court, or the federal courts can review all actions of the other branches of the government and the actions of the state and can declare things to be unconstitutional outside the case that they're in. They have power within the case, the parties that are in that lawsuit. But to expand their power beyond that makes them the strongest branch of government, and our founders said they were to be the weakest branch of government. They don't have that power.
Thank you for that, Mr. Cobble. All right, this will be our last question. We'll take a short break. How long is our break going to be, Dave? 10 minutes?
I think we got scheduled for 15.
Or we'll take a 15-minute break after these 5-minute responses.
Are we?
We're on the second question.
Okay. So you're talking about after this one?
After this, right. We'll take a 15-minute break, get something to eat, something to drink. All right, we'll go on now to the second question, which is for Mr. Pulliam. You have 5 minutes, Mr. Pulliam. Do you believe nullification is the rightful remedy when any of the three branches of the federal government steps outside its delegated legislative authority? Yes or no, and why?
Short answer is no. Now, as part of this, keep in mind that the concept of judicial review goes back to 1803, Marbury versus Madison. It was foreshadowed in the Federalist Papers, Alexander Hamilton's Federalist number 78. It's the fundamental concept in our Constitution. It is the heart of Article 3, the separation of powers. The Article 1 authorizes the Congress. Article 2 authorizes the executive branch. Article 3 is our judiciary. And the judiciary had a limited but very important role. And this idea that if we unleash nullification, we are not tearing up the Constitution, I'm afraid you are. That this idea that the only laws that will be nullified are the ones that are unconstitutional, well, people disagree about that. And it's the reason that we disagree about this is that we're in the situation that we are. The powers of the federal government have grown and grown and grown because many people believe and have voted accordingly that the Congress has the power to redistribute, to create a welfare state, et cetera. So no, nullification is not part of the constitutional scheme. The main way of limiting the federal government to its enumerated powers is internal policing by the three branches against each other. Also legal challenges, such as the ones that General Scarametti brings successfully to overturn federal regulations under Title IX that would put transgender kids in the wrong restrooms and locker rooms, etc. We have the 10th Amendment protecting states. We got Article 5 to amend the Constitution if the citizens disagree with how it's being interpreted. We have elections of both Congress and the President, and so forth. Now, I'm going to quote some language here, and they're harsh, but these are not my words. Okay, here's the quote. The frustration behind modern nullification talk can be easily understood. And even though many may sympathize with its overall objectives, every citizen who loves his country and his Constitution must renounce, reject, and oppose this mal doctrine. Mal meaning bad. Boldly confronting it at every venue where it raises its venomous head. Nullification is the hallmark of selfishness and anarchy, and selfishness and anarchy, whether by citizens or states, is not a cherished American virtue. To the contrary, a characteristic of America's greatness has been an unwavering dedication not only to follow the rule of law, but also to expend much time and energy necessary, no matter how long it takes, to make needed changes through the constitutional process. There will always be a losing side on every federal law. And some state will always disagree with every law passed. But under nullification, the losing side would always win. The losing side in any federal issue has two constitutional recourses available. It can attempt to convince a majority of the nation that the law is unconstitutional, and they can then remedy that law with a corrective measure in Congress. Or it can seek to have the federal law declared unconstitutional by the federal courts. Nullification places minority power above majority power. The majority may sometimes be wrong, but when that occurs, Washington reminded Americans that changes must be made only by using the way which the Constitution designates. But let there be no change by usurpation. For though this in one instance may be the instrument of good, it is the customary weapon by which free governments are destroyed. Very simply, don't try to fix the Constitution by breaking it. Fix the Constitution through the means it provides. And nullification is not that means. Nullification is a dangerous, anarchic mal-doctrine, cancerous and toxic to the health and vigor of a constitutional republic. Those words are from David Barton, the founder of Wall Builders, one generally regarded as one of the preeminent evangelical historians of our time. And I think, and many people, legal scholars, agree with that we have to take the Constitution as we find it. It created a judicial branch. It created a supremacy clause under the Article 3 as interpreted by Marbury versus Madison, which is one of the most durable landmark cases in Supreme Court history. And the supremacy clause states cannot second guess the interpretation of federal law or what is constitutional or not. And it is simply foolhardy to insist otherwise. This is as General Skermetti said, plainly unconstitutional.
Thank you, Mr. Pulliam. Mr. Cobble, the same question for you. Do you believe nullification is the rightful remedy when any of the three branches of the federal government steps outside of its delegated legislative authority? Yes or no, and why? You have 5 minutes.
Thank you, and obviously my answer is yes. It is a rightful remedy. It's not the only rightful remedy, but it is a rightful remedy. And let me just start by, I guess, a tip of the hat to David Barton. He's been a hero of mine for a long time. He's done a lot of great work in this country, but respectfully, he's just wrong on this issue. And the names that he called, yeah, that's what most people would call me, I guess. Some might go so far as to say it's a traitor. Well, call the name whatever you wish. I am defending the Constitution when I limit the power of the federal government. It's just that plain. Now, it's easy for a tyrant to say, we have the keys to the jail, we have the clubs, we have the bullets, and so anybody who doesn't agree with us is wrong and they're a tyrant, and that's what they're doing. Certainly, the majority of legal scholars say there is no such thing as nullification. I know I have an uphill battle, an uphill climb, but I'm telling you, I believe truth is on our side. And I will tell you that you can be right and still not win. In fact, one of the things I say, and I have a 40-hour course on the Constitution, and one of the things I give a nugget of truth, and one of those nuggets of truth towards the end of the course says, let's take divine law off the table for a minute, because there's nothing higher than divine law. But let's take human law. Only human law. The greatest human law is the law of conquest. Might as well think about it. We talked today about international law. What a joke. International law. Whoever has the biggest guns, whoever has the most soldiers, conquest is what wins. I don't want to see us have to go to conquest in this country. I want us to see if we can divide the powers back out to the states as they should have been originally, not allow this violation to continue. And respectfully, Mr. David Barton is just wrong on this issue. In fact, I emailed him one time and never got an answer. And one of the emails I said was to Mr. Barton, when the United States Supreme Court says that based upon the language of the First Amendment and freedom of religion and separation of church and state and all these, that's a false doctrine, by the way, under the First Amendment, but parents can no longer be involved in the religious training of their children. Some people say they'd never do that. Oh, really? Oh, really? They wouldn't? What do you do, Mr. Barton, when the federal government through the Supreme Court says that? Do you say, I'm going to appeal? Do you say, I'm going to try to get our state to pass legislation? I'm going to write letters. I'm going to protest. You know what I say? I'm not going to follow it. End of story. You don't have authority. Okay? You don't have authority to do that. And who says? I say. And the Constitution says. So all due respect to Mr. Barton, I think he's wrong on that issue. Now, judicial review. Again, I don't care how long something's been the rule of law. If it's wrong, it's wrong. Of all the things that you would think, you would find someone like, for example, let's say Clarence Thomas or Judge Alito being some of the strongest supporters of the concept of states' rights. The idea of judicial review is a fiction. I'm telling you, no law school is going to tell you that. Every lawyer I talk to, they think I'm crazy. But listen to me carefully. Here are the words talking about judicial review in Marbury versus Madison, 1803, that they got wrong. And I want you to listen. This is an argument before the United States Supreme Court. on abortion. And I want you to listen to about the first minute of this, which I hope I can make work. I'll just get to it in the next section, okay? I want you to hear what Justice Sotomayor says about this concept. So I'll stop with that.
All right, thank you. We're going to take about a 15-minute break here. We'll come back with 3 more questions and closing arguments. All right, first I want to compliment both Mr. Cobble and Mr. Pulliam. A very interesting question, well argued by both sides. So, we have 3 more questions. The first question will have a 10-minute response from each person. The next 2 will have 5-minute responses. And then each debater will have 10 minutes for a closing argument. Then I'll have just a few minutes at the end to close out the panel. So, let me begin now. We'll go with Mr. Pulliam. Question number 3. Do you agree with Tennessee Attorney General's opinion that the nullification process legislation here introduced in the state of Tennessee violates the separation of powers doctrine of the Tennessee Constitution? Yes or no or why? You have 5 minutes.
Yes. Yes, I do. And for anybody who's curious, I encourage you to go online and look up General Scarametti's opinion on this. It's very well done. And so they said it violated the separation of powers under Tennessee Constitution and also under the federal Constitution. And both constitutions have the same concept of a separation of powers because both constitutions created 3 separate branches: the executive branch, the legislative branch, and the judicial branch. And you have to think of these 3 separate branches as lanes. The legislature passes the laws, the executive administers or enforces the laws, and the judiciary interprets and applies the laws. Each branch must stay in its lane. On a highway, what happens when cars don't stay in their lanes? We have traffic accidents. In government, we have usurpation and dysfunction, and we have conflicts, in some cases very serious conflicts. The Civil War cost over 600,000 lives, and so conflicts are to be avoided. Now, the Supremacy Clause, and there's been a lot of talk here about states can decide for themselves what it is that is constitutional and what it is that isn't. And we're going to have a separate question later about the Supremacy Clause. But let me just say, in the Constitution, which was ratified by all of the states, they created a judiciary and they created a Supremacy Clause. So the states delegated to the federal government the ability, the right, the exclusive right to decide what laws are constitutional and what are not. And so that state's rights is not protected by the 10th Amendment because it has been delegated to the national government through the Supremacy Clause. But let's talk a little bit about SB 2775, because it isn't just a law that says the legislature can decide if federal laws violate the Constitution. It does more than that. One of the things it does is authorize the governor, a governor that many people in this room probably regard as a rhino. Okay, but under this law, that governor can unilaterally declare by executive order which federal laws are constitutional and which federal laws are not. Now, it wasn't that long ago Tennessee had a Democratic governor. If nullification is legitimate, it doesn't require statutory authorization in the form of SB 2775. We could have California Governor Gavin Newsom nullifying federal laws willy-nilly. So could the liberal governors of New York, Illinois, Michigan, Minnesota, and other blue states. Another thing that SB 2775 does is allow all state court judges in Tennessee, and we have, by my count, over 200 state court judges, trial and appellate, to decide in their courtroom, in any case that they have jurisdiction over, to decide whether a federal law is constitutional or not, and basically apply whatever law they decide is what the Constitution calls for. I cannot imagine a greater invitation for chaos is to have a bunch of judges in Tennessee not just disagreeing with the Sixth Circuit or with the U.S. Supreme Court, but disagreeing with each other. And so that's chaos. And it is ironic that the proponents of this bill place such faith in state officials whom they regularly belittle as establishment rhinos. How can you view as salvation the same group of legislators who have refused to even allow the nullification bill to get out of committee 3 years going? If all 50 states got into the nullification game, imagine the confusion. Not only could each state reach conflicting conclusions about federal law, but within each state, different officials could disagree with each other. Now, many prominent conservatives oppose nullification, not just General Scarametti. I mentioned some of these: David Barton, Mark Levin, John Eastman, Randy Barnett, scholars associated with the Heritage Foundation, Cato Institute, Americans for Limited Government, the Convention of States, the City Journal, the publication, the Independence Institute, Bob Natelson in particular. But as I've said, the only person who really matters is the Supreme Court. And the Supreme Court has decided this and decided it for all time, emphatically, more than once, going back hundreds of years. So this is a dead letter. Okay, and one of the authorities cited by General Scarametti, in his opinion, was Andrew Jackson's proclamation on nullification, and he issued this during the nullification crisis back in 1832. Andrew Jackson should be a very popular person in this room. He was a Tennessean, the first Tennessean to be president, and he was the original people's president. He was literally the precursor to Donald Trump. Now, when he denounced the South Carolina nullification laws, he said this. He says, quote, "I consider then the power to annul a law of the United States assumed by one state incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, inconsistent with every principle on which it was founded, and destructive of the very object for which it was formed, giving states an uncontrolled right to decide whether federal laws are constitutional is, in his words, an absurd and dangerous doctrine. Quote, the laws of the United States must be executed. I have no discretionary power on the subject. My duty is emphatically pronounced in the Constitution. Those who told you that you might peaceably prevent their execution deceived you. They could not have been deceived themselves. They know that a forcible opposition could alone prevent the execution of the laws, and they know that such opposition must be repelled. Their object is disunion, but be not deceived by names. Disunion by armed force is treason. Are you really ready to incur its guilt? Close quote. And reportedly, he warned South Carolina, quote, if one drop of blood is shed there in South Carolina in opposition to the laws of the United States, I will hang the first man I get my hands on to the first tree I can find. Now, you might say, well, SB 2775 doesn't go that far, but it does. It takes resources away. It says we oppose and so forth and so on. But it also says that nullified laws, quote, must be resisted, close quote, and deemed null and void in the state. So I think, for the reasons that we have talked, that it's just a non-starter to think that we can solve the problems of an overreaching federal government by passing a law that authorizes our legislature or our governor or our courts to simply thumb their nose at federal law. If we're unhappy with federal law, we should talk to our representatives, the Tim Burchett's, the Marsha Blackburns, the Bill Haggertys, to change the laws. We should elect Donald Trump in November so that he can continue the work of taking back the Supreme Court. We have a 6-3 majority, a conservative majority on the Supreme Court for the first time in my lifetime. So the idea that now we should start defying the Supreme Court when we have a Supreme Court that is overruling Roe versus Wade, recognizing the concept of presidential immunity, saying that the J6 defendants were convicted on bogus grounds. It's something to overruling Chevron. You could go down the list. We should be celebrating what the Supreme Court is doing, not trying to undermine it. So, the question, do I agree with Jonathan Skrmetti? I agree with him. If anything, it was understated. And I go into quite a bit more detail than he did in his Attorney General opinion. But if you want to know, further information on this, I would encourage you to go to my website, misruleoflaw.com, and look at the article that I mentioned earlier, which has hyperlinks to all of these different citations and supporting authorities. And I commend the spirit that supports this nullification effort. I just wish that those resources and energy was being directed in a more constructive manner.
Thank you, Mr. Pulliam. I never noticed this about this room, but there are some unusual acoustics here. If you're whispering in the restroom, everybody hears it. I know, it sounds bizarre. So if you would, just hold all your whispers and thoughts to yourself for the next 45 minutes or so as we finish this. Thank you for that. All right, Mr. Cobble. Question 3, you have 10 minutes to respond or to give your answer. Do you agree with Attorney General Skrmetti's opinion that the nullification process legislation introduced into the Tennessee General Assembly, which you, by the way, you wrote the draft of that, violates the separation of powers doctrine of the Tennessee Constitution? Yes or no, and why?
Well, no surprise. I believe that it does not violate the separation of powers doctrine, and I think I can explain why. First of all, from our Tennessee Constitution, we have a few unique provisions in our Tennessee Constitution, and one of those particularly is Article 2. Just after we have all the Declaration of the People's Rights, there's a long section in our Constitution, and in case you're interested, I teach a course on the Tennessee Constitution as well. I would urge you to study it as seriously and devoutly as we do the U.S. Constitution, because under my theory, there's more rights to be determined under Tennessee than under the federal government. But our Tennessee Constitution, Article 2, says distribution of powers. I want you to listen to this. This is impressive. Section 1, the powers of government shall be divided into 3 distinct departments: legislative, executive, and judicial. Section 2, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others, except in the cases herein directed or permitted. So unless it's in the Constitution, they cannot. Again, General Assembly cannot do what the governor can do, and the governor can't do what the General Assembly can do. Note COVID, for example. Okay, the governor can't make laws. So there's many examples in which our Constitution, both state and federal, have been, I guess, ignoring this rule of separation of powers. But Attorney General Skrmetti says that this legislation that we're proposing violates separation of powers, and I want to ask why and how. Because all I'm saying is, and all the law would be saying, is that the state General Assembly has the right to say the federal government does not have the power or authority. Now, how would that violate separation of powers? Only one way. Only one way. You know what that way is? Only the courts can do that. The only way that you can argue that the General Assembly can't say no to the federal government is to argue that only courts can do it. So I believe the General Assembly can. And I believe in our executive department, our governor. Now, here's another big issue. It's a big issue. I address it again in my courses. There's a fundamental misunderstanding about what executive orders are. So let me address that for a minute. Executive orders are not called executive orders because they're issued by an executive. Executive orders are called executive orders because they bind only the executive branch. Executive orders bind only the executive branch. The governor cannot order the people to do anything. He only controls his branch. And if the governor takes an oath to uphold the Tennessee Constitution and the U.S. Constitution, which has implied within it, not only implied but express, limitations of power for the federal government in lawmaking, remember, the president has no law to enforce if Congress can't make it, right? Congress has to have the power to make a law about something on the federal level before the president can execute it, before the courts can hear the case. So if there's no lawmaking power on the federal level, then the executive has no unconstitutional law to enforce. If the states cannot say no to the federal government, or if under our Tennessee Constitution, as our Attorney General suggests, we can't do that. You can't let the General Assembly do what only the courts can do. What I say is, show me in the Constitution where the courts can declare anything unconstitutional. This is the false notion again. It's a false doctrine of judicial review, that only courts can decide these things. And you referenced earlier, I looked it up, Mark, I appreciate your mentioning the Federalist Papers, which again are not legislative authority, but they're persuasive authority. And you mentioned the Federalist Papers, and I read the Federalist Papers a little bit differently than you do. I think that what it's saying is that judges have the right in the case in their courtroom to decide those things, but not to tell the other branches what to do. I don't think there's ever any authority. For the Supreme Court, I don't believe the Supreme Court can declare an act of the legislature unconstitutional. And that's what everybody thinks they're there for. But it's not in the Constitution. It's a made-up doctrine. In 1803, Marbury versus Madison. And it just so happens it lets me get back to this thing I couldn't show you before, because it's the same topic about separation of powers. And I want to show you, even a very liberal Supreme Court justice recognizes the fact that judicial review is not in the Constitution. So if you play about the first 50 seconds or so of this is an argument for the U.S. Supreme Court on the abortion case.
In history, tradition, it's a quintessentially legislative line.
Counsel, there's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison. There is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means. It was totally novel at that time. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. And here in Casey and in Roe, the court said there is inherent in our structure that there are certain personal decisions that belong to individuals and the states can't intrude on them.
The viability line
right
discounts and disregards state interests.
So notice what she says.
And the standard has all
There's nothing in the Constitution that says that. It's inherent. You know what inherent means? Unstated but implied. Well, let me tell you, friends, that we have an answer to unstated and implied. And those are called the 9th and 10th Amendments. I think Mark would agree with me. Nullification is not mentioned anywhere in the U.S. Constitution. And what I say is nullification is a right, and the states have the power to do that. And the fact that it's not mentioned in the United States Constitution, and it's a concept that's well known to the drafters of that document. They knew what nullification was. They did it here, Declaration of Rights in 1765, Declaration of Rights in 1774, the Suffolk Resolves, the Mecklenburg Resolves. The Mecklenburg Resolves from North Carolina prior to the Declaration of Independence said, abolish all these things the king has done. Get rid of them. The king doesn't have the authority to do that. Suffolk Resolve said, we're not paying any taxes. Wow. Our founders knew what it was to nullify, to stand up to a power and say, you don't have the power. And they did it. And listen, let me say, nullification is not right if it works and wrong if it doesn't. That's a false concept. That's false logic. There are many things that are right and they may not win. I'm suggesting under natural law, nullification is right. It does not violate separation of powers. And there is nothing in either the Tennessee Constitution or the U.S. Constitution, I double dog dare anybody to show me anything in there that says the courts are the final arbiters. They say it's implied. Well, here's the idea. If nullification is not mentioned in the Constitution, then the Ninth Amendment says that the rights not enumerated in the Constitution are reserved to the people. And the 10th Amendment says the powers not delegated in the Constitution to the federal government are reserved to the states and to the people respectively. If it's not mentioned, then we have the power. And if it's not mentioned, then we have the right. So, all the concept, and I don't fault the Attorney General's committee. He goes to the best law schools are teaching the wrong doctrine. I don't mind saying that. I'll say it on national television. They all teach it wrong. And I'm not trying to say I'm some bard that's figured this out. I'm just saying I've read it. I try to read it in time. I try to read it historically. And I try to read it in such a way that it makes sense. I try to give it textual support. And it means what it says, and it says what it means. And so there is no separation of powers. The governor within the executive branch can say, you don't have the authority to, in my branch, we're not going to enforce this federal law. It's not a violation. He's staying within the within his executive branch, which he has the authority to do. And so the concept on which Attorney General's committee has concluded that there's a violation of separation of powers, which Tennessee clearly says you can't do. Don't do what some other branch is doing. It infers, it's implied, to use Justice Sotomayor's, it's inherent power of the court. It's inherent for them to decide what's constitutional. And I call malarkey on that. Why does anyone else take an oath? If the Supreme Court's the only one to decide what's constitutional, why do we make our lawmakers and our executive branch and our governor take an oath? They take an oath because they're expected to do so. Andrew Jackson famously said to the Supreme Court, you've issued your opinion, let's see you enforce it.
Thank you, Mr. Cobble. Now we come to the fourth of our 5 questions. I'm going to double dog dare both of you to answer this question. You have 5 minutes. We'll start with Mr. Pulliam. Who do you believe the authors of the U.S. Constitution delegated the responsibility and duty as the final arbiter of the Constitution? Why, and what evidence do you have to support your response? You have 5 minutes, Mr. Pulliam.
Okay, so my answer is the federal courts and ultimately the U.S. Supreme Court pursuant to Article 3, which created the judicial branch. Alexander Hamilton, who was one of the delegates to the Constitutional Convention and a preeminent founder and one of the primary authors of the essays, 85 essays that were published in order to convince states to ratify the Constitution, wrote the Federalist Number 78, which is one of the most famous essays in the Federalist Papers. And he described the role of the judiciary. And this isn't a hoax. It isn't something that anybody made up. It is implicit. That is why you have a judiciary to, and that's one of the principal defects of the Articles of Confederation, is that there was no judiciary. So it was perceived as a check on the power of the legislature. If the legislature could pass any law it wants, then how do you keep them from exercising powers that are beyond its authorized jurisdiction in Article 1? Well, because we have the Constitution, which is the highest law. No law can contradict or infringe the Constitution. And how do we determine if a law contradicts our highest law? You have to have courts. And so that is what Article 3 did. The Supreme Court recognized the concept of judicial review in Marbury versus Madison in 1803. No precedent in the history of the United States is as well settled as Marbury. It's fundamental to our whole constitutional scheme. To say that it's a hoax and that we should disregard it and that nullification is the true way, I would suggest any doctrine that relies on the repudiation of a principle as well established as Marbury versus Madison is suspect. And as Chief Justice Marshall declared in the foundational decision of Marbury versus Madison, it is emphatically the province and duty of the Judicial Department to say what the law is. In Federalist Number 78, Alexander Hamilton said, quote, "The courts of justice are to be the bulwarks of a limited constitution against legislative encroachment." Now, these concepts that we're talking about weren't, created after the fact. When the Constitution emerged from the Convention Hall in Philadelphia, people had questions. This was a kind of a foreign doctrine. There was no precedent for the Constitution. It represented a lot of compromises among the 13 states. And there were people who were skeptical. How is this going to work? Will it work? And there was the reason that they wrote these 85 essays in the Federalist Papers is to answer these critics. And some of the critics, Brutus in particular, questioned what will this Article 3 mean for the Republic? And those were considered the anti-Federalist papers. And so this was an ongoing debate between people favoring ratification of the Constitution and those opposed to the Constitution. And some of the essays that Brutus wrote in the Anti-Federalist papers raised some of the same concerns that Mr. Cobble is raising. Like, well, where will it lead? What will happen if they start, making fanciful decisions and so forth? And those are the things that Alexander Hamilton was responding to. So this is nothing new. There were Anti-Federalists who questioned in the draft Constitution before it was ratified, well, we're giving Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. And they said, well, that's pretty vague. Well, it has to be. You are writing a charter for the ages, and you can't, it's not like a owner's manual of a car. And so they spoke in generalities. But the bottom line is, who is the founder who, for correctly or not, is most associated with the Constitution? It's James Madison. Not because he wrote it, it was a collaborative process, but because he was the chief note taker, he was a scribe. And later in his life, when, as part of his distancing himself from the Virginia Resolution, which he played a role in drafting, he wrote, and this is in 1834, he says, "But it follows from no view on the subject that a nullification of a law of the U.S. can, as is now contended, belong rightfully to a single state as one of the parties to the Constitution, the state not ceasing to avow its adherence to the Constitution. A plainer contradiction in terms or a more fatal inlet of anarchy cannot be imagined."
Thank you, Mr. Pulliam. Thank you. All right. Question for Mr. Cobble. I'll repeat it for you. Who do you believe the authors of the U.S. Constitution delegated the responsibility and duty as the final arbiter of the Constitution? Why, and what evidence do you have to support your response? You have 5 minutes, Mr. Cobble.
Thank you. I believe that the founders of the writers, drafters of the Constitution intended that the decisions about what's constitutional or not would be determined by the legislative branch on the federal level and or by the states, as the states' rights. So I believe that the topics that are assigned to the federal government in Article 1, Section 8, and a couple of amendments are the purview of Congress, and that they're the final arbiter of what is constitutional and what is not. And then with regard to the division of powers between what we would call horizontal, we have vertical separation of powers and horizontal separation of powers. By the way, I don't put the U.S. government here. I put the U.S. government here. All rights come from God. The people have the rights. States are next, having greater rights. The rights that the people delegate to the state government is second in line, and then what the states and the people delegated to the federal government is the last. So they're the least powerful. They have the least powers. They have the least rights. That's not a violation of the Supremacy Clause, because the Supremacy Clause says they are supreme in those little categories, but they're not supreme in the others. So I believe that's who we have that's who has the final say about that. Let me go back to one of the things I maybe ran out of time on. Andrew Jackson, who Mark rightly talked about, his statement about secession. I want to make sure you understand this. It's the same Andrew Jackson that when the Supreme Court ruled against his power, in the Indian Removal Act said, the Supreme Court has issued their opinion, let's see them enforce it. You see, it seems he understood something about nullification too. And every office holder takes their own oath. In fact, Andrew Jackson says, and it's one of the things in the preamble to the bill, he says, I take an oath to uphold the Constitution as I understand it, not as other people understand it. It's a fair point, right? Otherwise, it's just take an oath to follow the Supreme Court. So let's use logic, friends. Let's use our reasoning here. So the answer is, on the federal level, Congress. So let me burst another bubble. Some of the cases that Mark has cited, clearly he cited good United States Supreme Court cases. I'm not going to differ with the cases. I just think they're wrongly decided. And one of the things they say is that the branches of government are co-equal. Let me tell you, they're not co-equal. And they weren't intended to be co-equal. There's numerous Federalist Papers that says the legislative branch is the weakest. How can you be co-equal if you're the weakest? And let me tell you this. Congress has the power to fire the executive. What's that called? It's called impeachment. We've gotten to learn a lot about that in the last couple of decades, haven't we? They've got the power to fire the executive or some of the underlings. And do you know they can even impeach or throw out of office judges? So let me ask you, who has the greater power? The person with the power to fire or the person that can't be fired? Congress, the legislative branch, is the most powerful branch of government, state and federal. Tennessee, they can impeach the governor or judges. The federal level, they can impeach the president and or judges. The legislative branch is the most powerful and was intended to be the most powerful branch of government because they can control them all. No judge can remove. People ask me, how do we get someone out of Congress? I say, hope they die or resign or don't get elected. Or that their own members throw them out. The only way you get expelled from Congress is that your fellow congressmen throw you out, like they're about to do with Menendez, maybe, Senator Menendez. The courts can't touch the Congress. In Tennessee, the courts can't touch the General Assembly. So I disavow the concept that branches are co-equal, because they're not. If our legislative branches would exercise the powers, we wouldn't have this runaway Supreme Court stuff. They should have impeached some of these guys decades ago for infidelity to the Constitution. So let me tell this one story. It's one I use in the Institute on the Constitution that I teach. I've got 50 seconds. I bring a young man up, and I say to the audience, I find the youngest man there, typically a homeschooler or someone. He's maybe the last one I had was an 8-year-old. And I said, tell me your name. He tells me his name. I said, we're going to have a fight to the death right here in front of everybody. And just like the Philistines and the Hebrew people, whoever wins, everybody else is a slave. You've got to vote. Who do you think will win? Will I win or will the 8-year-old win? And if you vote wrong, you may die or be enslaved. And so people vote. And, of course, his mom votes with him. You know, most people vote with me. And I said, wait, you voted too soon. You voted too soon because you didn't understand what I'm about to tell you. He gets to make the rules about the fight. Now, what rules are you going to make? He says, you can't move. Now I lose. If you make the rules, you're going to win.
Thank you, Mr. Cobble. Thank you. All right. Our final question is going to be about the Supremacy Clause. Now, that's in Article 6, Clause 2 of the United States Constitution. I'll read it to you right now. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. And so that sets up our last question, and we'll go to you, Mr. Pulliam, for this one. Please describe what you believe to be the meaning of the Supremacy Clause as stated in Article 6, Clause 2 of the U.S. Constitution. You have 5 minutes.
All right. So you've read the text. This is really the essence of our disagreement, Mr. Cobble and myself, is what does a Supremacy Clause mean? And this goes to the heart of whether states have the right to nullify federal law. And what the words seem to say is that this Constitution and the laws of the United States are the supreme law of the land. The proponents of nullification say, well, you've left out in pursuance thereof, which shall be made in pursuance thereof. And they're saying it's up to the states to agree or disagree whether a law is made pursuant to the Constitution. In effect, we can second guess your judgment whether the law is constitutional. And that just is not a straightforward interpretation of the words, but it goes beyond that. The framers of the Supremacy Clause went out of their way to make it unmistakably clear that the national government was supreme over the state governments on matters involving federal law. And so they said that it's the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. So they were anticipating that a state might pass a law that says we disagree with this or we disagree with that or we find this law to be unconstitutional and therefore we don't have to follow it, because in Article 6 they said it's the supreme law of the land, anything in your laws to the contrary notwithstanding. And then to make it even more clear, they wanted it to be belt and suspenders. They added in the Constitution, which was ratified unanimously by the 13 states at the time, the senators and representatives, this is further down in Article 6, before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So they say it's the supreme law of the land. We don't care what your laws say to the contrary notwithstanding. And our Constitution says every state elected official has to take an oath promising to follow Article 6. And now we have a group of people saying, no, the Supremacy Clause means we can disagree. We're free to disagree. That would make a mockery of the Constitution. The lack of a judiciary was one of the great defects, as I've said, with the Articles of Federation. The Articles of Federation. Our country would not have survived if we kept with the Articles of Federation. That the Constitution was intended to create a union where we would have strength through unity. Unity can only be achieved if the nation speaks with one voice, which means that the national government is that voice, and when it comes to interpreting the Constitution, that voice is ultimately the voice of the U.S. Supreme Court. Now, for further elaboration on this, I encourage you to, pick up a copy of the Federalist Papers. Go online. They're all out there on the internet. Federalist number 22. Alexander Hamilton explains why the Supremacy Clause is so important to have national unity. Read Federalist 44, where James Madison explains why the Supremacy Clause is so important. And And in fact, here's a brief quote from Madison in Federalist number 44. He says, without the Supremacy Clause, as these constitutions invest the state legislatures with absolute sovereignty. He's talking about before you take away the Articles of Confederation, what do you have? You have 13 sovereign states, each of which have their own constitutions, vesting their state legislatures with absolute sovereignty. In all cases not accepted by the existing Articles of Confederation. All the authorities contained in the proposed Constitution, so far as they exceed those enumerated in the Confederation, would have been annulled, and the new Congress would have been reduced to the same impotent condition with their predecessors. The reason that the Founding Fathers met in Philadelphia in 1787 was to save the country, to discard the dysfunctional Articles of Confederation, and to adopt a constitution that would make us one nation, speaking with strength through unity. And you cannot have strength through unity if all of the states are free to go their own way. It's that simple. So the Supremacy Clause is the heart of this. Read it. Read what the Federalist Papers had to say about it, and I don't think how you can conclude that nullification is a viable concept.
Thank you, Mr. Pulliam. All right, last answer to the last question before closing statements. Mr. Cobble, question for you. Please describe what you believe to be the meaning of the Supremacy Clause as stated in Article 6, Clause 2 of the U.S. Constitution. You have 5 minutes.
Well, first let me say I agree about the importance of the Supremacy Clause. I'm not here to debate whether the supremacy clause is viable. It's clearly in the Constitution. The question is, what does it mean? And how's it to be understood? And what I say, the opponents of nullification say the supremacy clause means that the Constitution and anything else the federal government says is constitutional is supreme. And what I say is, no, the Constitution is supreme no matter what anyone else in the federal government or state government say. So I believe the supremacy clause is on my side, quite frankly. It's on the side of nullification. So I'm going to try to pull up something here and just review a few things to let you see how the wool is being pulled over our eyes in a lot of this stuff. Here we go. Bill of Rights. What rights are given to the federal government? The Constitution again says. We have 10 bills of rights that were all ratified after the Constitution. One of the things I want to tell you is that the Bill of Rights has a preamble, and almost no one knows what it is. If you go to the U.S. government and ask them to show you the Constitution, they don't include the preamble. And another very good organization, Hillsdale College, has published this. This is not anti-Hillsdale. I'm just telling you. You get their Constitution, they don't have the preamble to the Bill of Rights in there. They have the preamble to the Constitution, but not the preamble to the Bill of Rights. Well, maybe why not? Well, look at what the preamble says. It says, this is 1791, the conventions of a number of the states having, at the time of adopting the Constitution, and what that means, we're getting ready to adopt it, but some rules, okay, expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. The states are saying, if we ratify this, we want to make it plain. We want to declare, we want restrictive clauses about the power of the federal government. There's no question in my mind that the Bills of Rights are to bind the federal government. There's misunderstanding about that too. They've now tried to apply the Bill of Rights to the states through what's called the incorporation doctrine. Another court-created doctrine that's baloney. Complete and utter baloney. And they incorporate some things, they don't incorporate other things. They make it up as they go. I'm not questioning whether they're sincere or not. I believe they're sincere, they're just sincerely wrong. They're taking power that belongs to the states and the people. So I want us to go back and look at the Supremacy Clause. The judicial power of the United States shall be vested in one Supreme Court. And then Section 2, as Mark has rightly read, I appreciate he's being very honest about all these things. The judicial power shall extend in all cases in law and equity arising under the Constitution. This is another place that I think people misunderstand the power of courts. They only have power within their cases. They don't control the other branches. They don't have control over society. They only decide the case before them. It's plain in the U.S. Constitution. It's plain in the Tennessee Constitution. The power extends to cases in law and equity that arise under the Constitution and the laws that are made pursuant. So you can't make a law not pursuant to the Constitution. And if you do make a law not pursuant to the Constitution, like, for example, COVID, or whether landlords can evict people during an epidemic, or whether red flag laws, apply. Should we pass red flag laws? This guy's psychologically imbalanced. We need to take his guns away. We need to what? There's no power for them to do that. And so the question becomes, is the Supremacy Clause say the federal government is the only one to say whether the federal government has the power to do that? Or do the people and the states retain the rights to say, I call baloney, I call malarkey, you don't have the power? So to be sure that we're clear, I'm not suggesting states can do whatever they want. I'm suggesting states can do whatever they want in non-federal areas. And as I said before, I'd like to see a little more confusion. I don't like what's called unity. Unity is not a good thing when you don't have the same values. It comes up in church sometimes. Christians ought to be unified. And I tell people in our congregation, every time you say people ought to be unified, you need to ask them back, unified around what principle? Now we'll decide if we're unified or not. No false unity is going to save us. We need to stand on our principles, and the people have God-given rights, and so do the states.
Thank you, Mr. Cobble. All right. We're going to now move on to closing arguments. Each debater has 10 minutes. We'll begin with Mr. Pulliam.
All right, thank you. So I want to extend my thanks to this audience, which has been very patient. What has been a long afternoon of what may seem at times tedious argument. Now, SB 2775 is called Restoring State Sovereignty Through Nullification Act. Sovereignty means who is in charge or who governs. We are a constitutional republic, not a democracy, and our sovereignty consists of democratic self-government under our state and federal constitutions. One nation. And the idea that the Founding Fathers wanted or thought that chaos was a good idea, they thought that chaos was worse than tyranny. That to have ordered liberty, you have to have order. And so in Tennessee, the citizens are in charge. We have a Republican governor, supermajority Republican control of the General Assembly, a conservative state Supreme Court, and a conservative and very effective state attorney general. We have no state income tax. When my wife and I moved from Texas, Austin, Texas, which is not really Texas at all, but anyway, to Tennessee 5 years ago, we were literally in Austin behind enemy lines, and we picked the volunteer state because it appeared to us, after studying many different states, to be the most conservative place in America to live. And to this day, I don't regret it. We got Tim Burchett, Marsha Blackburn, Bill Hagerty. You know, I'd say that's as good as Texas or any other state in terms of representation in Congress. We have, thanks to President Trump, for the first time in my lifetime, a 6-3 conservative majority on the U.S. Supreme Court. Hallelujah. Can I hear a hallelujah? Hallelujah. Yeah. We've been waiting for this for decades, and now we have it. Our intermediate federal appellate court, the Sixth Circuit, is pretty conservative and generally upholds conservative statutes passed by our General Assembly when they are challenged in court. Recently, for instance, the ban on all ages drag shows was upheld by the Sixth Circuit. The statute requiring birth certificates to reflect sex on birth so that they can't be modified due to some delusion that your gender has changed, that was upheld. The U.S. Supreme Court has recognized presidential immunity, which is a doctrine that's not expressly set forth in the Constitution, but it's implied by the structure of the Constitution. So that's what you have to do sometimes, because the Constitution isn't an owner's manual, it's an outline. And it has to be filled in through experience, through stare decisis, through interpretation. And so they recognized presidential immunity, rejected the bogus theory Colorado wanted to use to keep President Trump off the ballot, overruled the Chevron doctrine and Roe versus Wade, and clarified that many J6 defendants were improperly charged under an inapplicable statute, the Sarbanes-Oxley bill, and more. On many fronts, we are winning. Why would we want to advocate a policy undermining the Supremacy Clause when conservatives control the Supreme Court? I gather that a lot of the support for nullification originates in despair about the direction of the country. And I agree, things are not going well in all respects. But citizenship requires civic engagement, and you in the audience are the tip of the spear. But get engaged in a way that can make a difference. Nullification is unrealistic, like supporting third-party candidates. If the people in this room want to strengthen grassroots power, they could start by working to increase the deplorably low voter turnout, especially in primary elections, electing true conservatives to local offices, and that means city councils, county commissions, county mayors, which throughout Tennessee are full of rhinos. Maybe we should start with the low-hanging fruit before we start trying to redesign the constitutional order. And we should run and elect conservatives to serve on the Tennessee Republican Party State Executive Committee, transforming the county Republican organizations where you live into meaningful outlets for conservative grassroots participation. Of all the things that we discovered when we moved to Tennessee, the feeble state of the Tennessee Republican Party is our biggest disappointment, and it is the state's biggest shortcoming. And by the way, Michelle Foreman, who is running for the state legislature in Williamson County, when she served on the SEC, then living in Davidson County, voted with a number of other members of the SEC to nullify my write-in election. I was elected with 302 write-in votes to be the committee man for District 2. The election was certified by the Secretary of State. The SEC, at the instigation of some rhinos, including Scott Golden, the Republican Party chairman, with Michelle Foreman's support, nullified my election and 302 write-in votes and appointed some rhino crony. So I think we have to be rigorous, but let's be rigorous about things that we can have control over, like fixing our dysfunctional Republican Party. We can urge the General Assembly to close the primary to prevent Democrats from having a choice in the selection of GOP nominees. Cut off welfare benefits for illegal aliens. Require Tennessee employers to screen applicants using E-Verify. There's a whole laundry list of things. I don't want to be, you to leave here thinking, well, the difference between Jeff Cobble and Mark Pulliam is that Mark Pulliam is not a stalwart conservative. I am. I think there's a lot of things that we can do, and we could do if we were working together in a constructive way to make Tennessee even better. Channel your efforts where they can make a difference. But the best way to shape the direction of the federal judiciary and the deep state is to elect President Trump in November and send him a conservative Congress to help him drain the swamp. And we can't take anything for granted. That we saw what happened 4 years ago. So volunteer for his campaign. Send him a donation. Put a sign in your yard and a bumper sticker on your car. Do what you can to make sure that the Trump-Vance ticket wins. SB 2775 is just a replay of Jackson versus Calhoun. That argument was fought and decided almost 200 years ago. That battle, like the Civil War, has been fought and lost. And that nullification is a defiance of the federal government. It's really an insult to our constitutional order, the notion that we are one nation. The day for disunion, rebellion may come, but are any of the people in this room prepared to say now that they are prepared to mutually pledge to each other our lives, our fortunes, our sacred honor, to abort the Union, as the signers of the Declaration did? Are you willing to rebel, to go to war against the federal government? I don't think so. Our national motto is e pluribus unum, out of many, one. That's, it's not a call for chaos, it's a call for unity. And so I would suggest use your energy and resources to fix your Republican Party and state government here in Tennessee, even your county and city government, before tackling the federal Leviathan. And I will just leave it there. Thank you.
All right. Thank you, Mr. Pulliam. Mr. Cobble, you have 10 minutes for your closing argument.
Thank you. First of all, Mark, man, thank you for your stand on all those issues. I mean, we don't differ. I say, amen, go for it. And Mark is also right that we have limited resources. I agree with all that. I'm not suggesting that you abandon everything else and go after nullification. My father has a famous statement. He has a real Christian. I would call him. He's an evangelist, not a preacher. He doesn't, but he gives out tracts and witnesses and so forth. He's a real evangelist, and he basically says, develop multiple tactics. Okay, not everything works for the same people. He says, fish with more than one hook. That's a good concept. I'm all for it. The big difference is I'm saying fish with all these hooks, and he's saying don't fish with this hook. Let's be clear, that's what he's saying. Don't fish with this hook. And I'm saying, why not? So remember, Senate Bill 2775 doesn't require the state to nullify anything. We say it's a nullification bill, but it doesn't require them to do anything. It requires them to consider the issue and vote on it. Now, one of the things that Mark said in the opening, which he's absolutely right about, we don't need this bill to nullify. I think it's a natural right. So some people say, why pass the bill? We already have the power. And I agree we already have the power. But I don't agree that we don't need to pass the bill. The reason we need to pass the bill, no one knows that we have the power. and no one knows how to actually go about doing the things that need to be done. And I wish for a governor that would say, whether the court system supports my view on this or whether the General Assembly supports my view on this, I say the federal government has no power and we will not enforce it in Tennessee. I don't think that brings disunity or chaos. I think it brings control and it brings constitutionality back to the table. Now, are there governors that would act disingenuously? Of course. Could liberal states use this the concept of nullification to their advantage? Not could they. They already have. Some people say you can't nullify. I had this conversation with, I won't call the name, someone well known to most of the people in this audience. Nullification is not a thing. You can't do that. And I said, nullification is alive and well in this country if you're a liberal. They're the ones who say, we will not enforce immigration laws in our state, sanctuary cities, sanctuary states. They're the ones who say marijuana, recreational use in our state. Now, you can argue whether that's I believe marijuana use was not given to the federal government. I think they have no right to make a statement about that. But while they have it, they're using nullification to say we will not enforce that in our state. And it's alive and well. And they're doing it by the dozens, by the hundreds. What I say is it's high time that some conservatives begin to understand federal constitutional principles and limited government, and that we begin to enforce it. Now, what will that mean? I don't know. This is not a silver bullet. We can't pass this legislation and fix all the problems. Remember, it's only the bill only requires the General Assembly to consider and vote on the issue. And even if they vote no every time and don't nullify anything, I will be glad that they know they're supposed to think about that. Would that encourage any of you, if you know that we're at least thinking about, should the federal government be doing this or not? Should this be reserved? So it doesn't mandate them to do anything. It specifies that they have to consider the issue, which I think has immense value. We may need to take more steps beyond that, but it's a good starting point. But I'm not suggesting that this fixes everything. I'm not suggesting that this is the only issue that conservatives ought to care about. All of these issues Mark's brought up are vastly important issues. I'm just saying, also try this one. Why not? Mark's right. We have what some people say is a 6-3 majority. I still wonder if it's truly 6-3. In some cases, it's clearly not. But yes, we're making progress. And I'm not disappointed. I mean, I'm not one of these who go, oh no, that's terrible. I wish it would just get worse so we could use nullification. Well, that's ridiculous. I believe in principles, not politics. Okay? And I'm suggesting there's a principle at stake here, which is that God gives rights not to government. Government has no rights. It's not organic. It's a created thing. God gave rights to men. Men then assign those rights to government. And may I tell you, this question comes up a lot when I talk about nullification. I hate to have to bring it up in this audience, but you're a very astute audience, so I'm going to lay it on you. We may have to nullify sometimes state action that violates the state constitution. Do you know the state government can also violate the Constitution? And again, I hate to go back to COVID, but where are epidemics mentioned in our state constitution? They're not. So where does the state government get the power to make health care regulations? And they don't have that power. It's a made-up thing. And so the concept of nullification, again, is not anarchy. We get this from people all the time. It's anarchy, blood in the streets, wild beast will consume us all, the sky is falling. No. It's a restoration of structure, federalism. The concept that law is not just what man says it is. That's the concept of positive law. Positivist in the concept of law is that there is no law except what man says. I'm not a positivist. There is a law no matter what man says. Benjamin Franklin famously said, "He who spits against the wind spits in his own face." And what I'm telling you is we have some states, and particularly the federal government, has for decades, I'm talking about in the early 1900s, and then it got worse in the 30s under FDR, and then we, oh my goodness, then we get separation of church and state in Everson, and then the train wheels fall off after stuff like that. Separation of church and state nonsense. We've been going down this road for a long time. If people simply understood the powers properly given to the federal government, and they would have stood on those issues long ago, we wouldn't be in the shape we're in now. So I'm an advocate for trying to return to originalism. What was really meant? Does it say what it means, and does it mean what it says? And I say it does. I'll remind you again that he who makes the rules will win. Keep that in mind. Whoever has the power to make the rules will win. Now, maybe the person with the power to make the rules is a benevolent dictator. And maybe they've got the power to make the rules, and maybe they're nice. And that's great. But I tell clients when we write contracts, sometimes they come to me for contracts, and I say, we don't write contracts for when people agree. If everybody agreed, you wouldn't need a contract. You write a contract for when there's a disagreement. Let's decide those things now, and let's bind both sides to the terms of the contract. And then if things go well, we don't need the contract. We don't need a court to enforce it. If things don't, we need the contract. I say the same thing about our system of government. We want to hope for the best and plan for the worst. And I'm suggesting to you that no founding father, perhaps some exceptions, I don't know all about their lives, but certainly the majority of the founding fathers believed that they were making the federal government supreme over every area of their life if the federal government said so. No rational person would believe our founding fathers did that. What's our Tennessee Constitution say? After the Constitution was adopted, we will be a free and independent state. What does free and independent mean? And so, I'll take you back to about 3 months ago. I had a conversation with an attorney in my office, and I don't know how in the world he knew about the concept of nullification, but he mentioned Representative Halsey. He was an attorney from Kingsport. He said, we've got a representative up in our area. It's introduced this thing called nullification. He goes, man, is that ever crazy? Now, of course, he didn't know I had anything to do with it. Okay? We were in there for civil litigation. So I just keep quiet. Oh, okay, really? Crazy? So, yeah, that's crazy. And I said, well, why do you think that's crazy? He said, how in the world are we ever going to make that work? And I said, well, let me ask you a couple questions. Do you believe in states' rights? He goes, well, yeah, I guess I do. And I said, if states have rights, what are they and how do we know? And he said, good question. I don't think about that much. I said, well, where are you politically? He said, I'm probably, you would call me maybe left of center. And I said, well, I'm falling off the edge of the globe on the right, okay? So we don't have much in common here. But if we have states' rights, what are they and how do we know? And he said, I guess you'd look in the Constitution. Bingo. What parts of the Constitution? Article 1, Section 8, plus perhaps some things under the 14th, which, by the way, it's greatly misapplied. That's how we know what the rights are and who gets to decide. The states and the people do.
Thank you, Mr. Cobble. All right, let's give a round of applause to our two debaters here, Jeffrey Cobble and Mark Pulliam. And let me just close out and say thank you, everyone, for coming today, and a salute to our friends at the Tennessee Alliance. Yes. Been around since 2008, I think, right? Wasn't it? 2010, right as we started the Tea Party movement, and been a great force for liberty and the Constitution here in the state of Tennessee. I thank everybody for coming, and stick around and talk to the speakers, and we really appreciate your coming today. Thank you.
Let's get a hand for the moderator. But anyway, I want to thank everybody for coming, and we're going to take a few questions here. And what's your question, Karen?
Oh, I have a couple questions. It's not, well, of Mr. Pulliam, and you talk about the issue with the Calhoun decision. Okay. What happened there was Calhoun was trying to nullify something that was a federal authority. And that's why his act of nullification was shot down, because he was violating the Constitution by nullifying something that was constitutional to begin with. So that's just a little clarification on that issue. And you seem to like quotes of our founders. I have a couple here that I find very interesting. The power under the Constitution will always be in the people. That's George Washington. The states being the parties to the constitutional compact and in their sovereign capacity, it follows of necessity that there can be no tribunal, which is a court or forum of justice, above their authority to decide in the last resort whether the compact made by them be violated, and consequently that as the parties to it, they must themselves decide in the last resort such questions as may be of sufficient magnitude to require their interposition. This was James Madison. So he's basically saying that there is no court above the people in the decision as to whether the compact is being violated. The several states that form that instrument, meaning the Constitution, being sovereign and independent, have the unquestionable right to judge of its infraction, and that nullification by those sovereignties of all unauthorized acts done under the color of that instrument is the rightful remedy. And this is Thomas Jefferson. And the last one, the powers delegated by the proposed Constitution are few and defined. Those that are to remain in the state government are numerous and indefinite.
Well,
Was there a question in there?
all right, so let me, this is something that comes up often in the whole nullification dialogue. First of all, Thomas Jefferson said this, Thomas Jefferson said that. Thomas Jefferson was not in Philadelphia the summer of 1787. He was not a delegate to the Constitutional Convention. He was in France. He was the minister of France. He was in Paris, and he was kind of a romantic revolution. He supported the French Revolution. He famously said the tree of liberty must be watered with the blood of patriots. He liked the idea of having conflicts. He said, for instance, that we ought to just tear up our Constitution every 10 years or so and redo it. So he's not, I consider, a representative of the
I had 4 different people here.
Okay, all right. So let's go, James Madison. Okay, so you're quoting from some of the language from the Virginia Resolution. The Virginia Resolution is extremely verbose. It goes on for thousands of words. Basically, it says we don't like the Alien and Sedition Act. Okay, it had no legal effect. He uses the word interposition. He doesn't use the word nullification. And as I've said, subsequently, he did a report in 1800 on explaining what the Virginia Resolution. He backed away from that, said, oh, we were just expressing our opinion. It was just our opinion of whether this law is good or not. He made it clear, we do not have the authority to declare something unconstitutional. Only the courts have that authority. And this is, people can quote a lot of things, but if you want to know what James Madison said, I suggest you read my article. I have links to the text of all of these remarks that it's on file with the National Archives. It's not just the Virginia Resolution, but the 1800 report. And then he wrote, there's some correspondence that he did, and then finally, in 1834, he wrote probably the most definitive statement and basically said that if the states had the right to unilaterally nullify federal law, it would be nonsensical and we would have anarchy. And so I'll just leave it at that.
Mark, can I just jump in on that? I agree with that, okay? But the question is, what is federal law? That's the question, and who gets to decide that? And so that's where all these quotes, I think, that's where the issue really is. We don't differ on much, I don't think. I guess we differ on judicial review. I'd like to have a discussion with you sometime about that. Maybe there's something I'm missing, but and separation of powers. But that's what it comes down to. Who has the right to decide what is federal law? I don't believe, you didn't ask me the question, Karen, but I'll just answer. I don't believe the states have the right to nullify what's legitimately federal law. We're stuck with it. Too bad. We should never have given them that power. But I believe we have the power to say you weren't given the authority in that field. Okay? You can't decide energy. You can't decide whether I can buy a natural gas appliance or whether we can dig coal out of the ground. You don't have that authority. We didn't give you that. That's the issue here. It's a narrow issue, really, in a sense, I believe. But I do agree with Mark that the quotes don't have really legal precedent. I'm arguing under natural law, okay? And I think you're arguing under the text of the Constitution, Supremacy Clause, and so forth. But just a brief commercial, not that I need people to be there, but 1 week from today, I'm going to do a whole 5-hour presentation on this topic in Greenville. If you're interested, you can talk to Dave Vance about that. And he may have more to ask me on Monday night, I don't know. But anyway, if you want to hear the whole 5 hours, which talks about unalienable rights, where do they come from? How do we know what they are? How do we enforce them? That'll be next week at 1 o'clock in Greenville. Dave, do you have other questions?
Thankfully, I'm not an attorney, but I'd like your comments on a couple of things. These aren't laws, but they were Supreme Court decisions. 40 years ago in 1984, the Chevron deference decision. Recently, the Supreme Court just said, oops, we were wrong. Now, for 40 years, Americans have suffered under that. Businesses gone bankrupt, families divorced. There could have been some people even commit suicide. 49 years ago, they made a decision, Roe v. Wade. Millions of children were killed under that. Now, with nullification, we could have nipped that in the bud 40 and 50 years ago and stopped it. But going the traditional route, we have waited 40 and 50 years until someone challenged it, went through, and finally the Supreme Court said, sorry, we were wrong, and they reversed it. Now, it's interesting that Roberts, in this last one, Roberts said, and I'm just paraphrasing, the decisions that were made under the Chevron deference, we're not going to retry those, even though hundreds or thousands of decisions were made and lives were ruined, but we're going to assume they were okay. And of course, under Roe v. Wade, we can't retry and bring the babies back. So I'd like your comments on this, because with nullification, we could have stopped that. But the traditional way, we had to wait 40 or 50 years. And just another comment with gun laws, we know there are gun laws since 1938, so they're unconstitutional. One of these days, some court is going to come and say, sorry, we got that wrong. And the millions of people that have been jailed and imprisoned, we can't go back and say, well, sorry. So what are your comments now about nullification versus waiting until some court wakes up and says, sorry, we got it wrong?
So the Constitution is not perfect. Men are not perfect. Men make mistakes. You give men power. They sometimes use the power incorrectly. And you can go back through American history and you can point to a lot of bad Supreme Court decisions. Dred Scott may have precipitated the Civil War. Korematsu, authorizing the internment of Japanese Americans. A long list. The question, I guess, Chevron is a decision that at the time that it was issued empowered Ronald Reagan's administrative agencies to make regulations without being vetoed by the D.C. Circuit, which Ruth Bader Ginsburg at the time was sitting on the D.C. Circuit. For a long time, Chevron was a popular decision. Antonin Scalia defended it almost his entire tenure on the court until he died. But the point is that in time, these mistakes were corrected using our institutional mechanisms. And I would challenge you that, so if we had nullification, we could have prevented the abuses of Chevron. How exactly? So let's say that SB 2775 was passed, that the requisite number of, or either somebody in the General Assembly proposed a resolution, or some cities and counties petitioned, or a number of citizens petitioned. In any event, we get something in front of the General Assembly that says basically, we think that Chevron, and why would Chevron be unconstitutional? Because it violates Article 3, because it involves judging cases, and administrative agencies are not entitled to do that. So, okay, so let's say that such a petition got filed and submitted, and let's say that it got heard on the floor of the General Assembly. Now, whether it was approved or not, at the end of the, so you could have Tennessee saying, we disapprove of the Chevron doctrine. Well, I'm sorry. What Tennessee thinks is not going to affect the way the courts review administrative agencies in the federal courts, and that's where these regulations get reviewed, is in the federal courts. So so saying that we don't like it, during the course of Chevron, many people, books were written condemning Chevron. So it's not like it got a free pass. The good news is it came to an end. It came to an end under our institutional processes, and we should, instead of complaining, Roe versus Wade was an abomination, but almost every legislature in a red state was calling it an abomination. People were protesting all these years, calling it an abomination. So if the Tennessee General Assembly had issued a resolution saying we don't agree with Roe versus Wade, what were you going to do? Shut down the abortion clinics and then have federal troops come in, just like the 101st Airborne came in to integrate? So it sounds like nullification would be a solution, but as a practical matter, it wouldn't be a solution, and we should be happy that due to President Trump's Supreme Court appointments, we're fixing problems, and there's still a lot of problems that need to be fixed, and with a second term, I'm hopeful that he will make that happen.
I've got a question for you, Jeff.
Do I get a quick response to that one?
No, yes, go ahead.
Okay, first of all, let me just say, it may be that nullification, that states suffer. I'm not trying to hide the ball with anyone. They may deny funding. That's the biggest tool they have. If you do this, we'll take away your dollars. And what I say is, well, I'll drive around potholes for my principals. My principals aren't for sale. If we drive around potholes, build our own bridges, maybe shut down some schools, maybe some state universities, maybe that'd be something we could think about doing. I don't know. But, I'm willing to suffer if I need to for my principles. And so my answer then on the Chevron doctrine is that the Chevron doctrine, I think, was wrongly ratified in the first place. I'm glad to see it be repealed and set aside. But I go even further. Maybe that won't surprise you. I go even further than that. I say the enumerated powers of the United States Constitution do not give the legislative branch the power to make other lawmakers. Therefore, every time they say to the EPA or to the Department of Interior, make your own rule. Oh, we won't call them laws. They're rules. But they have the force of law. You can be fined, you can be incarcerated. I say Congress needs to make all laws, and they should assign no lawmaking, rulemaking, regulatory authority to define the rules to any administrative agency. So we didn't go far enough in repealing Chevron.
Yeah. One thing on the judiciary at the federal level, okay, Article 3, Section 2, and you guys will correct me if I'm wrong, says that Congress can restrict the appellate jurisdiction of the Supreme Court, correct?
That's correct. Article 3,
and they've
Section
done it.
2, paragraph.
They have done it in recent history, not just ancient history, okay? So a lot of the things that we've allowed the federal government, the judiciary to have rule over, we really should have been pressuring our Congress to take that away from them. And then back to the AG's decision, I think it's pretty much, it's actually even worse at the state level. At state level, and correct me if I'm wrong, the judiciary only has appellate jurisdiction. It has no original jurisdiction. And oh, by the way, our state legislature,
State Supreme Court.
The state Supreme
Yes,
Court.
state
Our
Supreme
state
Court.
Supreme Court, they can have their jurisdiction. The legislature can make laws for them. Their power can be curtailed. So for the AG to say that it was a violation of separation of powers, that doesn't sound to me like that's accurate.
And so I would agree with that there's not a complete wall of separation, to use that fictitious term as applied to the First Amendment. But yes, I believe, again, the legislative branch is the most powerful branch and has the right to control or discipline or remove any other bad actors in any of the other branches. So that's where I don't agree that that's a separation of powers question or issue.
Right. Did you have a follow-up?
So, Dave,
Yeah.
so I agree with you. There's this notion implicit in some of the nullification rhetoric that a bunch of ninjas descended from black helicopters in Washington, D.C. and hijacked the federal government overnight and cheated us out of our Constitution with the limitation on the enumerated powers and so forth. And if that were the case, I think we would probably be able to rally people to, well, let's take it back. But how did we lose our constitutional government? How is it that the federal government, the Congress, ended up with all the power, all the administrative agencies, the deep state? How did that happen? Well, it happened through a series of elections, that we let it happen. Not only did we let it happen, we voted in favor of it. And so the New Deal, the Great Society, all of this garbage, in fact, some of it happening under Republican presidents.
Held up by the court. Supported by the court.
Okay,
Right?
but it's not like you can blame it all on the courts. So that if we want to take the power back, we have to take it back the same way that they got it, election by election, law by law, and in case of litigation, this comment about further curtailing the administrative state. I think it's coming. That this was just the first shoe to drop. What Jeff is talking about is the non-delegation doctrine, which used to be the law. It got overridden during the New Deal, but it used to be the case that Congress could not delegate lawmaking authority to unaccountable legislators. And if we're patient and if we support and get President Trump elected, it may be that in his second term we're going to see some things happen with the non-delegation doctrine that will make everybody in this room very happy.
Yeah, hope so. Hope so.
Can you hear me? Okay. First comment, Trump is not a savior. Trump is not the savior of the world. I mean, I agree with him, but he's not the savior of the world. He's not going to correct anything that's wrong. In the Constitution, would you agree that there's nowhere that it says separation of church and state?
I agree with that.
Okay.
Okay, but this is
Don't-
another
let
one
me-
of these
then
phrases
how can the
that's
court
floating
rule it?
around. Thomas Jefferson, in his letter to the Danbury Baptist, and somehow it ended up becoming
So
constitutional.
how did the court rule that way then? And how do we fix that?
Well, we have a number of organizations that litigate First Amendment cases.
And they get nowhere.
What?
And they get nowhere.
Well, they make in progress. So someday we're going to revisit the Establishment Clause jurisprudence, which took a wrong turn, under the Warren Court. But okay, so let's say they got it wrong. How is the Tennessee General Assembly going to fix that?
We start teaching God in schools. That's how we do it. We disagree with their ruling.
Something really simple, my simple brain.
Okay, hold on just a second. I gave him the mic, so after he speaks, then you can ask the question.
Oh, thank you.
You had mentioned we shouldn't be throwing our resources going down this nullification road. If it's my opinion that something's better than nothing. So if we don't go down this road, what would you suggest we go down?
Well, I've laid this down. So I'm not saying that protesting things, this is what James Madison was talking about in the Virginia resolutions, is that if you condemn a federal law, if you organize the states, remember, prior to the 17th Amendment, senators were chosen by state legislatures. So when you had the Virginia or the Kentucky legislatures saying, we hate this law is despotism, what they're really saying is, and we're counting on our two senators to vote against it. But how did the Sedition Act end up going away? Well, it ended up going away because Jefferson and his Republican Party beat John Adams at the ballot and won the election of 1800, and the law expired by its terms, and then he pardoned all the people that had been convicted under it. That, sometimes you have to rely on elections to solve problems, or constitutional challenges. Article 5, you can amend the Constitution to fix things. Putting the right people on the court can make a big difference. And so one of the reasons maybe that Jefferson won the election in 1800 is because they made the Alien and Sedition Acts toxic. And it wasn't because they declared it unconstitutional or said it was unconstitutional in these resolutions, but because they fomented opposition to a law that was already unpopular and made it even more unpopular. And we can certainly do that without, having SB 2775 on the books.
Okay. I have a question back here.
Okay, I think I'm just kind of piggybacking on Dan's question. Really, a short answer, short question, short answer. When you're talking about nullification, hold this one, okay. When a nullification back in 1973, it was Roe versus Wade. If we had nullification back then, I'm kind of confused because isn't healthcare something that the government shouldn't even be involved with in the first place? So why would a law coming out of Congress have anything to do with abortion when it really should go back to medical ethics question? So I'm kind of confused on nullification, Roe versus Wade, and is it really the Supreme Court and the Congress's business in the first place?
You want to go first? Or I can?
Well, so the thing about Roe versus Wade is it was not a bill passed by Congress, supposedly authorized by Article 1. It was an announcement of a constitutional right to have an abortion. And, you know, you can look all you want. You can't find any support for that in the Constitution.
That's right.
So, but once the Supreme Court decides something, just like they decided Brown versus Board of Education and said that schools have to be integrated, states are no longer free to say we disagree and we're going to defy it. That's exactly what Orville Faubus did in Arkansas, and the Supreme Court slapped him down in Cooper v. Aaron, a unanimous decision. They all signed, and Eisenhower slapped him down by sending in the 101st Airborne. So this idea that if we were opposed to Roe versus Wade in Tennessee, that we could continue to, you know, enforce our pre-Roe versus Wade abortion laws, which turns out were so strict that it became controversial after Dodd, is what would have happened? The Justice Department would have filed suit. They would have enjoined the state of Tennessee, and they would have enforced the law. So, you know, the Supremacy Clause is what it is. The federal courts have this power. You can question judicial review, but it's been the law for over 200 years. It's not going to change. And so there are certain things that the only processes available to you to change things is through litigation and through Supreme Court appointments, and that's what we did.
And my answer to the question would be that, again, Roe versus Wade overturned laws, and as I understand it, all 50 states. I'm not a scholar on that time period, but I believe every state had restrictions on abortion. And it just invented a doctrine. That's just what it did. It read the 14th Amendment. It found eminences and the penumbra and fancy words, blah, blah, blah. They just made it up. And finally, thankfully, we've got the Dobbs versus Jackson case that comes along, and they call their hand on it. You made it up. Nonsense. This is a state issue. So we were wrong since 1973. What could have been done? I'm not exactly sure what could have been done or whether it would have worked. I'm not here to tell you that nullification, if done, will work. It might not. It's still the right thing to do because they don't have the authority. And maybe it's a matter of numbers. So what if Tennessee would have said, we're going to nullify that, we're not changing our abortion laws, or let's take it to the marriage decision, okay? We have a constitutional amendment in Tennessee about what marriage is, and now they've announced their decisions. They've even gone to Bostock and other ridiculous concepts about what marriage is and transgenderism is. States should just say, no, we're not going to do it. And if Tennessee stands alone, we may go under. We may lose. We may, who knows? I don't know what will happen. But if Tennessee does it, maybe Alabama will jump on board. Maybe Wyoming will jump on board. What I'm saying is, it's principles that matter. And you ask a question, Mark, at the beginning, an excellent question. Are we ready to say we pledge our lives, our fortunes, and our sacred honor? My answer is yes. That's my answer. And so if we can do it peacefully through nullification first, I can keep my resources because I'm not going down this path. And I hope elections will change it, but what's going to happen in 4 years? Who doesn't run again? And what's the next administration? We have to change our principles. Not just the people, not just the players in D.C. The constitutional principles must be restated, re-understood, and taught in our schools and school systems, and if not in our school system, in our churches. I beg of our churches to get involved and start teaching these things because they're God-given rights. And that's my answer to that one.
I wanted to thank you both for coming this afternoon to be able to talk with us and educate us. One of the questions I had for you was if you could please describe to me, or the room if you would, under what power did the president have at the time to deploy the American military against U.S. citizens, and what constitutional right was he given and working with under?
Yeah. And what is there a specific incident that you're referring to?
Yes, when 101st Airborne was deployed under what constitutional authority did Eisenhower have to deploy troops against U.S. citizens? And why, and so the last part is, why has that never been done again?
Well, it has been done again. They sent federal troops to Alabama to enforce the court orders integrating the University of Alabama. And every time there's an injunction in federal court against something that a state does that is deemed to be unconstitutional, implicitly the full forces of the federal government are behind that. So where does the authority come from? Well, so without getting into the merits of Brown versus Board of Education, it was decided, and under the Supremacy Clause, that is the final statement of whether the 14th Amendment requires public schools to be integrated, and that the courts have the authority to do that pursuant to Article 3. So when you have a state saying, we're not going to do it, then the federal government says, well, you're defying the Supremacy Clause. You're not allowed to do that. And in order to enforce federal law, which is paramount to state law, we are going to force you to comply with a federal court order that you're thumbing your nose at.
But that's not what I asked. I asked, the 101st Airborne was specifically deployed to that area there. I'm not talking about guarding Washington,
the Insurrection Act, and they sort of nationalized the National Guard, and so what all the statutory rubric is under that, I can't say, but it was done to enforce a federal court order under the Supremacy Clause. And if you have any questions about this, go look up Cooper v. Aaron, 1958, and if you think that there's some residual ability of states to defy federal law and federal court order in light of Cooper v. Aaron, I'm sorry. All you can say is, well, I disagree with it, I'm going to ignore it. Just like you can say, I'm going to disagree with Marbury versus Madison and ignore it. But disagreeing with it and ignoring it doesn't change the fact that it is federal law and has been for hundreds of years, and it's respected landmark decisions. And so you talk about spitting in the wind, that's what you're doing. You're spitting in the wind.
Well, you've left us with resources for us to go check out of your material. I would implore you to check out Chris Ann Hall. She can give you a whole new education on what it truly means. Thank you, though.
And I can answer the question. I don't think there was a constitutional provision that authorized that. I don't think that there was. They say the 14th Amendment gave them the right to deal with desegregation. I question whether that's legitimate or not. But even if it is, the calling into action of troops against states is a whole separate question. And so I don't believe that I find authority in the Constitution for that.
Okay, that was going to be the last question. Please give a round of applause to these guys again. Thank you very much, gentlemen. Really, really good. If you have not signed up on the Tennessee Alliance distribution list or email, please do. We'll keep you informed on what's going on. And thank you very much for coming.